All right. Thank you, everyone, for being here and getting settled promptly after the break. If you haven't had a chance to purchase your books yet, they will be available at the second break as well. So I'm pleased to continue our panel with the second panel this morning, Contemporary Perspectives on Citizenship and Equality. Professor Riva Siegel, who will serve as the moderator, is the Nicholas D.B. Katzenbach Professor of Law at Yale Law School. Her work focuses on questions of law and inequality and how courts interact with representative government and popular movements in interpreting the Constitution. You'll find two of her articles in your CLE materials today. First, She the People, the 19th Amendment, Sex Equality, Federalism, and the Family, which is a 2002 Harvard Law Review article in which she first set forth an argument for grounding gender equality law in a synthetic reading of the Reconstruction Amendments and the 19th Amendment, and her recent Yale Law Journal article, The 19th Amendment and the Democratization of the Family. Together with BWLN Faculty Director Professor Melissa Murray and Kate Shaw, she is an editor of the recently released Reproductive Rights and Justice Stories. We are honored to have her moderate our second panel. Riva?
Okay, thank you. And thank you, the whole of the Birnbaum Center and dear Melissa for the organizing of this great conference, and it's just a fabulous first panel. So what we are going to do in this next panel is to move our focus to the present and to the future. And I'm going to tell you a bit about the group that we've got lined up to shift our focus from constitutional history to constitutional law and politics. And I'm going to first give them to you in alphabetical order, although you'll see that as we begin to talk, we're going to mix ourselves up a bit. Sarah Bramfman is the Senior Policy Counsel at A Better Balance, where she works on legislative advocacy efforts to advance policies that support working women and families. Her main focus at the moment is federal, state, and local efforts to end discrimination on pregnancy and provide for caregiving needs, including policies such as the Pregnant Workers Fairness Act, the PUMP Act, breastfeeding rights, caregiver rights, and workplace equality and fair pay. Kristen Clark, there you go, is President and Executive Director of the Lawyers Committee for Civil Rights Under Law, one of the country's most important national civil rights organizations. Under her leadership, the organizations intervened in some of the nation's biggest racial justice questions in areas of fair housing, community development, economic justice, voting rights, educational opportunity, criminal justice, and judicial diversity. Diana Kasdan, NYU grad, 2001, is Director of Judicial Strategy at the Center for Reproductive Rights. And in this role, she's leading an interdisciplinary legal team working to articulate and advance constitutional principles protecting reproductive rights as fundamental human rights. She's leading the Center's Supreme Court amicus campaign in support of the case June Medical, which will be argued next month, the first major abortion case to be heard by the court since Justice Gorsuch and Kavanaugh were appointed. She has over 15 years of experience as a reproductive rights and public interest lawyer, including nearly a decade at the ACLU, where she litigated reproductive rights cases with a focus on the rights of women who are incarcerated. Julie Sook, there, is the author of a forthcoming book, We the Women, about the past and future of the Equal Rights Amendment. And from what I know of this book, it's likely to be this generation's authoritative account of the ERA. Julie is Professor of Sociology and Political Science at the CUNY Graduate Center, where she also serves as the Dean for Master's Programs, and she was previously a law professor at Cardozo Law School. Wendy Wise, right over here to my right, is the Vice President and Director of Democracy Program at the Brennan Center for Justice here at NYU, where she's directing research, policy development, and litigation on issues of voting rights, money in politics, redistricting and representation, fair courts, and litigation, and abuse of power, She's helped to develop and draft a series of democracy reform proposals that were consolidated into legislation that passed the House of Representatives this year as H.R. 1, the For the People Act. Previously, she was senior attorney at Now Legal Defense and Education Fund And she points out, once upon a time, a first-year law student in one of my classes, someone else on the panel also had some other such relationship as well. All right, so I'm going to say a few words. I'm going to say a few words about the general arc of the panel, something at least to throw a few tools on the ground to help move us from the domain of history to the domain of law and politics. And it's really an impossible task in a few minutes, but I thought that I would at least try to sketch out a few concepts that we might draw upon in that project. And to do so, I'm going to point to two different kind of collective memory frames that seem to me important given the subject matter areas of the people on this panel, and then talk about how we could invoke them to shape law. So the first collective memory frame is, I would call the dominant collective memory frame of the centennial this year, and certainly one you heard about in the panel earlier, is about the wonderful diversity of the women who sought political or fought for political voice, the forms of intersectional discrimination they faced, the political coalitions they forged, and certainly, and now I'm thinking of Rabia's amazing slides, the betrayals of sisterhood on the path to suffrage, everything that we heard earlier this morning in waves that run from the early 1900s all the way through to the 1965 Civil Rights Act and all the way to the present. So that's one collective memory frame, sort of the range of voices seeking political suffrage, political empowerment. Another, and probably less conventional frame, but important to the stories you're going to hear today, is that the centennial is also about the family, about the democratization of the family. So I'm going to take a minute to sketch that out. I've written about this, some in my work, and others are beginning to a bit as well. Here we go. The men who wrote the Constitution and the Reconstruction Amendments justified male suffrage on the grounds that men, husbands and fathers, represented the women of their families. That was the structure that a male-only suffrage regime was justified through. And further, women sought the vote to democratize the family. That's part of what it meant to seek the vote. But not only by getting the vote, they made arguments for why they needed the vote. That empowerment was about changing law to change the conditions of family life. They sought the vote to transform the law governing the conditions under which they conceived and raised children and the conditions in which their families would grow and flourish. And if we look over the long history of the suffrage campaign, we'll see waves and waves and waves of different kinds of laws that the women who mobilized for the vote talked about what they needed the vote for to change. And I'm not going to take all of the time we would need to recount that, but temperance, anti-lynching, the industrial workplace, and when they got the vote, healthcare, we could go on. Okay, so how do we take these two collective memory frames and turn them into law? So I'm going to just throw out some concepts. One, history gives us negative precedent, wrongs that have been done that we need to right. It also gives us positive precedent, great heroines that we want to emulate. And I'm thinking just even of the wrap-up, Martha Jones invoking Mary Church Terrell, or we could think about Frances Harper or other strong women who we want to make a part of our law. The memory of whose heroism should be part of our democracy law, our constitutional law. Two, in making claims on the Constitution, we don't need to focus on the 19th Amendment alone. We can speak intersectionally across all the Constitution's Reconstruction amendments, all the amendments taken together. The struggle starts in the early 19th century, and there's a long intersectional history that runs through all of these amendments together that we can make claim on together. Three, and this is where we're going to get to setting up the panel now, we don't need to only rely on courts. Important thing there. Don't only rely on courts. This is where we're starting our panel now. Every one of the Reconstruction amendments has an enforcement clause. So too does the 19th Amendment have an enforcement clause. And I'm going to read you, the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of sex. Congress shall have the power to enforce this article by appropriate legislation. That enforcement clause, because of racism at the time of ratification, was never used in the 1920s. People should read Paula Monopoli's book that's coming out. It's a really amazing history of this story in the 1920s. But the 19th Amendment could have a second reconstruction, like the Reconstruction Amendments had a second reconstruction. And we could just imagine ways in which there could be legislation that enforces equality, and our panelists are going to talk about ways in which we could legislate on behalf of equality going into the second century. We're going to, also people might be interested, Rick Hazen and Leah Littman have an article posted now on ways to imagine a new 1902 power for people who are interested in enforcement powers. But in any event, going into the panel now, and I'm going to start us running, Julie's going to go first. The prompt is not to get in the weeds of the enforcement clause jurisprudence, but rather simply to imagine if there was going to be a legislative agenda to advance political equality going into this century, what might it look like? Where might we press the levers of change? And that's where our panelists are going to begin conversation. And the plan is they're each going to speak briefly for about 5 minutes, and then we're going to have a group discussion, and then we're going to turn it over to you all.
Well, I want to thank Melissa Murray and the organizers for this spectacular event. So I'm going to start with the present, which is last week in Virginia. Virginia actually became the 38th state to ratify the Equal Rights Amendment. This was an effort that was largely driven by women in the state legislature in Virginia, including very influential women of color. You'll see Eileen Filler-Corn, who's become the first woman speaker of the House of Delegates, and behind her, Jennifer Carroll Foy, a graduate of VMI, who was the sponsor of the ERA ratification bill. You can't really see her, but holding up her hand is Louise Lucas, who serves as president pro tempore of the Virginia Senate and presided over the crossover vote last week to ratify the Equal Rights Amendment. And then Sharnielle Herring, who is the House of Delegates majority leader and the first African-American woman to be in that role. And there was an effort in the Senate, too. The patrons of the bill were two women of color, Mamie Locke and Jennifer McClellan, in the Virginia legislature. And this is a historic occasion. Much of the debate in Virginia about ratifying the ERA, something they had been trying to do in the legislature for the last several years, but finally succeeded this year. So much of the argument had to do with being on the right side of history and the ERA being a legacy of the 19th Amendment in the centennial year of the 19th Amendment. Virginia was not alone. That is, the three states that ratified the ERA in recent years, after a deadline, which is the source of a lot of political and legal controversy right now. But the three recent ratifications in Nevada, Illinois, and Virginia, which were led, which happened in 2017, 2018, and now in 2020, all of these efforts were led by women of color elected to state legislatures in Nevada. In Nevada, there was Pat Spearman leading the effort, and then in Illinois, Iris Martinez, and Juliana Stratton, who went on to become the lieutenant governor of Illinois, I think the first African-American woman to be elected lieutenant governor of Illinois, who gave speeches about the importance of ratifying the Equal Rights Amendment today. The Equal Rights Amendment, of course, is directly linked to the history of the 19th Amendment because it was introduced in 1923 on the heels of the 19th Amendment. This is the text of the ERA, which eventually changed after the original text in 1923, but has now got the 38 ratifications as required by Article 5 to be added to the Constitution, notwithstanding the legal and political status of the deadline. But if we look back to the introduction of the Equal Rights Amendment, and today as we talk about the 21st century Equal Rights Amendment, the person who is most often solely credited with authoring the Equal Rights Amendment on the heels of the 19th Amendment is Alice Paul. Alice Paul was the head of the National Women's Party, and that's a picture of her unfurling the banner with 36 ratification stars. You needed 36 in 1920 to ratify the 19th Amendment. And one thing that was known about Alice Paul was that when a state ratified, an additional state ratified the 19th Amendment, she actually sewed the stars onto the flag herself. And almost as though it was like a personal victory every time you got a step closer. And you'll see in the picture of Alice Paul sewing that star onto the National Women's Party banner, looking over her, immediately to her left is Crystal Eastman, a 1907 graduate of this law school, who had actually had a career before the 19th Amendment was ratified, authoring a path-breaking book on workers' compensation and as a lawyer representing workers. So she's there, and in fact, she was actually, along with Alice Paul, an author of the Equal Rights Amendment as well. She, in 1920, as soon as the 19th Amendment was ratified, said the 19th Amendment is actually not the victory at the end of the struggle, it's actually a new beginning. And when she talked about that beginning, it wasn't just about voting. It was about equal pay, equal education, by which she meant educating boys and girls to overcome traditional gender roles, voluntary motherhood, including access to birth control, and what she called a motherhood endowment, which we would know as paid maternity leave and other supports for motherhood. And the Equal Rights Amendment that they introduced in 1923 was embodied all these different notions of women's equal citizenship. And so just to end on that note and bringing it back to the present, it's important to look at what the women are doing in Nevada, Illinois, and Virginia. In all of these state legislatures that have recently ratified the ERA, these same women, in many cases, have been very active in introducing Pregnant Worker Fairness Acts as state legislation, successfully in Nevada. In Nevada, some of the women who are active on the ERA also introduced a breastfeeding workers accommodation bill, and a bill that protects domestic violence workers from termination, domestic violence victims from termination in the workplace. And in Virginia, as we speak, the women who have been patrons of the ERA bills have also been sponsoring a Pregnant Worker Fairness Act and many other forms of legislation that would improve women's status both in the workplace and in many other areas of life.
Okay, and so I think Diana is
Yeah,
next.
I'll go for it.
Okay, go for it.
And is this on? Yeah? Okay. So as everyone else said, thank you for the organizers and for inviting me. It's really an honor to be part of this panel. So tasked with this, imagining a synthetic reading of the Reconstruction Amendments that would advance women's equal citizenship, I obviously want to discuss why this would be particularly important from a reproductive rights perspective. And so I think since it's switching gears a little bit, I do think it would be helpful to just lay the table a little on where we are with the state of constitutional rights for abortion in particular, and what that means for gaining protection through court litigation or even the ERA if it was passed. I do have to say, around the debate on the ERA, people have been reticent to address whether it would protect abortion rights, so that's a big issue. And then move on to why, this idea of using Congress's enforcement power is particularly important now. So reproductive rights are, of course, well-grounded in the 14th Amendment's Liberty Clause. The Supreme Court's held a host of personal decisions relating to family life are protected under the Liberty Guarantee, from the right to marriage, to raise your children as you see fit and determine their education, and of course, the right to access contraception and abortion. But the Supreme Court's also recognized that this freedom is central to women's equality. So as the court said 2 decades ago in the case Planned Parenthood versus Casey, quote, "The ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives." So just looking back a little, since that right was first established in Roe v. Wade in 1973, nearly 50 years ago, court decisions have really reshaped it in the law and in terms of reality on the ground. So of course, people know from the start, it generated great controversy and great opposition. And quite quickly, there were decisions from the Supreme Court that really rolled back the right. So I think it's important to mention these, because in particular, there were a string of decisions that said, even when the government funds health programs that are for all health services, including pregnancy, okay to exclude abortion care, and that is not a violation of the constitutional right to access abortion, and it's not a violation of equal protection principles. So already that, that was shortly 3 years after Roe established the right to abortion for poor women. It was becoming quickly inaccessible. Fast forward to about 1992, we're at a place where we are similar to today. There's a presidential election looming. The court had changed since the Roe decision, with a number of justices whose views were unclear on abortion or known to be hostile. In the next year, in Planned Parenthood v. Casey, the court did affirm the core holding in Roe, but in the same breath, it took away that strict scrutiny analysis that is the most protective level of judicial review for constitutional rights, and instituted what is known as the undue burden test. And it's a balancing test. And in doing so, they did give much more deference to the state's interest in promoting childbirth, right? Determining for women that the best outcome is having a child as opposed to terminating the pregnancy. So that really tilted the scales. And in that decision, they upheld restrictions that really would have been struck down under strict scrutiny standards, such as a 24-hour waiting period, a mandatory parental involvement law. So given that, people were really fearful that this decision had rendered the constitutional right subject to nothing more than rational basis review, kind of the least rigorous standard. So the next 2 decades tested that theory with mixed results in court cases where many laws were challenged as many more laws were passed. And it wasn't until 2016 that the legal standard was actually revisited, and that was in the Whole Woman's Health v. Hellerstick case. And that's one that the Center for Reproductive Rights litigated, challenging a Texas law that had literally shut down about half the clinics in the state. Okay, so if that's not an undue burden, what is? And not only did the court say, yes, this is undue burden, and Casey requires that, it also really clarified and reaffirmed that this is not a deferential test that the state can just advance any reason to justify its laws restricting abortion. Courts really need to look at how serious those burdens are, whether the law is actually advancing a legitimate interest, and if the balance is on the side of outweighing by any measure the state's interest, the law should be struck down. And it explicitly rejected arguments from Texas at the time that Casey really was essentially rational basis. So that was hugely important, but of course, not long after that, the landscape in our country and the courts changed quite dramatically. And we're kind of back where we are, with people predicting that the court is possibly about to reverse Roe versus Wade or Planned Parenthood v. Casey. And I want to say, well, that fear is not totally unfounded, because to be specific, we're back challenging the exact same law. So Louisiana passed the same law Texas passed. The Fifth Circuit saw fit to uphold that law despite this prior Supreme Court precedent. And we actually are in a position of having to challenge that. We shouldn't be, so that's worrisome. That said, I do want to say, because given what we read in the news, we don't think the court is going to reverse Roe v. Wade in this decision. And it might never do that. And I think we have to prepare for the damage that's going to be done if the court issues a series of decisions that roll back rights short of reversal. And the damage in Louisiana will be immediate. It's going to be down to 1 clinic in a state for 1 million women of reproductive age. And that would make it the 7th state in the entire country that only has 1 clinic. So as bad as that sounds, I do have to acknowledge access has already been tremendously burdensome and decimated for many women across the country, in certain regions of the country, and especially for women of color and low-income women, right? In Louisiana, it's about 62% of women seeking abortion are women of color, and nationally, about 75% of women are low-income and poor. And this problem extends far beyond Louisiana, because what we've seen since 2011, like we've seen in the voting rights space, is that the change in the state houses opened up the doors to an onslaught of restrictive legislation aimed at liberties, and nearly 450 restrictive laws have been passed in the states since 2011 aimed at abortion. So today we have nearly 90% of the counties without any access to a provider. So how the court decides this is hugely important, both in terms of the law and in terms of real access on the ground. And given how disparate the impact is, I want to say there have been efforts to litigate in ways that address the intersection of restrictions on liberty rights that are also discriminating on the basis of sex and race and class because of the disparate impact. And maybe I'll save it for questions or discussion later, but there's a lot of challenges we face in raising those claims in the courts. I'll just, flag a few. They've rejected sex discrimination claims in abortion cases in the past. Poverty is not a suspect class. You can't rely on disparate impact when you're bringing a constitutional claim. And finally, where we are now is we have a Supreme Court where we know the majority of justices are hostile to reproductive rights, abortion rights in particular. We have a federal judiciary that is also increasingly hostile, and we're going to be stuck with this for decades. So in short, we need to look to other solutions beyond the court more now than ever. And so that's where I would want to point to the Women's Health Protection Act, which is federal legislation that the center helped develop. It's been introduced in Congress since 2013. It now has 215 sponsors, and it does rely on the enforcement clause of the 14th Amendment to say that it is an obligation and authority with Congress to ensure access to abortion nationwide, so that is a right that is in reality accessible regardless of what state you live in. So I'll be very interested to hear how the other proposals about congressional reform could kind of help build on that and strengthen that approach to providing a national baseline of protection for reproductive rights. Thank you.
Thank you. Okay, so now Sarah's up.
So I'll echo the thank yous to Professor Murray, to Abby, Claire, and the whole Birnbaum Women's Leadership Network, and to my fellow panelists. So for those who aren't familiar, A Better Balance is a national legal advocacy organization that works to ensure that all workers and caregivers are able to both care for themselves and their families without compromising their economic security. And in doing that work, we work directly with workers. So we have a legal hotline, it's national. Anyone can call us if they are having trouble at work, they are pregnant and they think they're being discriminated against. They're providing care for a parent, for a loved one, for a partner, for a dear friend, and we'll talk to them. And in doing that work with workers and directly with clients, we have found certain realities to be true. And one of those is around pregnancy discrimination and the persistence of pregnancy discrimination. And the law that Julie referred to, called the Pregnant Workers Fairness Act, I think is a really good sort of way of showing how, like Riva was talking about, the 19th Amendment is a conduit to transform the law. And what the Pregnant Workers Fairness Act is a bill in Congress, but it is now law in 27 states, where employers have to provide reasonable accommodations for pregnant workers, so things like help with heavy lifting, a stool to sit on, bathroom breaks, in a lot of cases, space to express milk. And the reason that law has come about and the need for that law has come about is because the Pregnancy Discrimination Act, which was passed in 1978, is a hugely important law. It has really transformed how women work in the workplace, but when it comes to accommodations, aspects of that law have really proven difficult. And what we were finding is that women were calling us, and pregnant workers were calling us and saying, I'm being pushed out because I have a doctor's note that says I shouldn't lift, but my employer won't provide me that accommodation. And so I either have to work without that accommodation and risk my health, or I have to go out onto unpaid leave or just be terminated, and then I don't have a paycheck and I'm a single parent and I no longer have bread to put on the table. And we've actually seen that because one of our clients, Armanda Legros, was pushed out and she did not have enough money to put milk in her child's cereal while she was pregnant. So those are the stories we were facing. So our co-founder, Dina Baxt, wrote an op-ed in 2012 in the Times and spoke about this phenomenon and what we were seeing. And in 2012, Congress introduced the Pregnant Workers Fairness Act, which would put in place a framework where employers have to provide these accommodations unless it would be very difficult or very expensive. It's similar to the standard that's in the Americans with Disabilities Act. And a lot of people say, well, why is there a need for that law if there is the Pregnancy Discrimination Act? And the reason for that is because the Pregnancy Discrimination Act said that employers only have to treat workers the same who are similar in their ability or inability to work. Now, as we've spoken about with Riva extensively, there's still a disparate impact claim in the PDA.
Judges won't enforce it,
They
that's
just,
all.
yeah, courts won't enforce it, and that's why relying on courts is very problematic. And so the similar inability or inability to work is really a way of saying you need to show that someone else is provided that accommodation who is similar in their ability or inability to work, and then you can get the accommodation. So courts have interpreted that in many different ways. Some will say, well, if the person has an on-the-job injury and we accommodate them, well, then we don't need to accommodate you because pregnancy is an off-the-job injury. Although someone made a very interesting point where if the person got pregnant at work, maybe it would be. You know, that standard, and then some will say a pregnant person can't be a comparator, they have to be a non-pregnant person. But mind you, how is that similar in your ability or inability to work, since pregnancy is not the same as, let's say, you get to work because you drove drunk and lost your license, and now you can't be a UPS truck driver, and so we'll give you light duty for that. And so Young versus UPS was a Supreme Court case that was supposed to clarify that standard, and we wanted to look into whether it did clarify that standard. And so we recently released a report in May called Long Overdue, and found that over 2/3 of courts were still rejecting Pregnancy Discrimination Act claims for accommodation cases. And over 70% of those were because of this comparator standard, where you need to find someone else who is accommodated. So the Pregnant Workers Fairness Act gets rid of that. It goes to an individualized inquiry. And how that sort of relates to the equality framework is that, you know, we've spoken, Riva has really been a thought partner, and Julie has been a thought partner in this work. And really what we're thinking about is, when we're thinking about equality, the whole point of the PDA was to ensure equal treatment and to get at multiple forms of biases: unconscious bias, conscious bias, structural bias around pregnancy. And really what we're trying to do with the PWFA is extend the PDA and the concept of equal treatment. By putting in an individualized inquiry, it really says, let's look at the pregnant worker, one pregnant worker, and their experience, and what they are experiencing and what they need, as opposed to assumptions about what a pregnant worker needs. Assumptions that they shouldn't be working because they're pregnant. Assumptions that they should be able to work but need an accommodation. And so that's really what it does, and that's how it furthers the equality and citizenship argument.
Thank you. All right. So, Kristen, thank you. Thank you, Wendy.
Good morning. So I want to first start off by thanking Professor Melissa Murray for having the leadership and vision for this convening, and the staff at the Women's Leadership Network, and also just briefly recognize two extraordinary civil rights lawyers in the room, Deborah Archer and Catherine Powell, both of whom have done great work in the civil rights space, and I think any student who has them today is incredibly fortunate. I'm going to talk a little bit today about voter suppression efforts and how these efforts bear more heavily on women, and on Black women and women of color in particular. But first, just some context, kind of how we got here to a place today in which voter suppression efforts are as intense as they are. And that's for a few brief reasons. One, we've got a 2013 Supreme Court decision, Shelby County, Alabama versus Holder, which cut out the heart of the Voting Rights Act, a provision that helped to prevent discriminatory voting changes from taking effect in about 16 states that were covered in whole or in part in the country. And that federal review mechanism is now not in place, and has basically given a green light to many jurisdictions across the country to work actively to turn the clock back on voting rights. Two, we have a president in place who signaled very early on in his tenure that he was deeply committed to promoting voter suppression, and he did that by putting in place an election integrity commission that's now defunct and dismantled, but no doubt send a very strong message to states that they should use this kind of claim of vote fraud as a basis for actively working to make it harder for people to vote, for communities of color, women, students, and low-income people in particular. 3, we have a Justice Department that is out of business when it comes to enforcing the Voting Rights Act and other federal voting rights laws, leaving the burden to other organizations and individuals to do what work they can to fight back. And then 4, we are living in an increasingly diverse nation, and one in which incumbents in particular, many of whom are disproportionately men, and white men in particular, are very bent on changing the rules and rigging the rules of the game to hold on to their grip on power, not creating space for women and for people of color. So all of that informs a backdrop in which we see a number of places today that have put voter suppression efforts in place. And again, I want to just talk about those briefly and how they impact more heavily on women and women of color in particular. So Texas, I'll start there. On the day that the Supreme Court issued its decision in 2013, Texas announced that it was moving forward with a restrictive voter ID law in order to vote. Now, Texas was a place that had an ID requirement in place prior to this that was very broad and had a lot of latitude. There were many forms of ID you could present. You could present a utility bill. But under this bill, they intentionally narrowed it to a few categories of ID, one of which included a conceal and carry permit. Data from about 2 years ago shows that there are about 1 million people who have gun licenses in the state of Texas. About 75% of them are men, and the remaining amount are women. But when you overlay this with race, it underscores the stark racial impact. Only about 6% of people with gun licenses are African American, and the numbers of African American women are minuscule. So no doubt the state knew who they were locking out when they narrowed the category of IDs in the way that they did. There's been long protracted litigation over this that we mounted at the Lawyers Committee along with the Brennan Center and other groups that ultimately helped to soften the edges of the law. But one case that I wanted to bring up. A second comes out of North Carolina. This is a state that also actively worked to suppress the right to vote. Following this Supreme Court decision, they put in place a bill that turned the clock back on voting rights in many respects, leading up to a Fourth Circuit decision that found that state lawmakers acted with almost surgical precision in the way that they restricted the right to vote. But let me just briefly talk about what they did with respect to ID. A study produced by the Southern Coalition for Social Justice showed that there were about 318,000 voters in the 2012 election cycle without ID issued by the DMV. And they found that all of the registered voters who were impacted by the new ID law, about 64% were women and 36% were men. And when you overlay this with race, that also compounded the impact. So no doubt that the way that North Carolina, I'm already out of time. No doubt the way that North Carolina chose to restrict the right to vote was a way in which women were impacted, but Black women in particular. All across the country, we're seeing efforts to shut down polling sites. We're seeing in Georgia, we fought an effort that was led by the former Secretary of State, Brian Kemp, an exact match requirement in which the state chose not to process registration forms unless all of the information provided by a prospective voter matched perfectly information in the state's database. Our analysis showed here that this impacted people of color, but again, women in particular, women with married names, hyphenated names, that for whatever number of reasons didn't match up perfectly with the state's databases, which were riddled with errors and often outdated. I'll close by just talking a little bit about Black women in elected positions and Black women prosecutors in particular, who increasingly are targeted. These are women who have been elected by the people and who face tremendous hostility and recalcitrance and efforts to strip them of power. We're seeing this with Kim Gardner in St. Louis, where there's almost a conspiracy underway to undermine her efforts to promote criminal justice reform. We're seeing this with respect to Rachel Rollins, a woman of color out of Suffolk County, Massachusetts. Attorney General Barr recently waged an indirect attack on her efforts. She has pledged to curtail prosecution of low-level offenses and has drawn the ire of Barr. We're seeing this with folks like Prosecutor Aramis Ayala out of Orlando, the first black elected prosecutor in Florida's history. She vowed not to seek the death penalty, and the former governor took the unusual step of taking a high-profile death penalty case away from her and reassigning it to another county. I could go on and on with examples of this, but no doubt we live in a democracy today that set its sights on disempowering voters of color, disempowering women, and we're also seeing the impact when we look at the few numbers of black women who have successfully been elected to office in a number of places around the country, particularly into prosecutorial seats and into judicial seats around the country.
Okay, thank you. All right, Wendy.
All right, well, thank you so much. It's a real honor to be part of this discussion and to have the opportunity to step back and to think about the fights for political equality that we've been engaged in through the lens of the 19th Amendment and all of this history and all of the linkages that I'm hearing. And as a matter of law, the 19th Amendment has been largely dormant. It's not really doing anything. But as a matter of fact, we've seen so much energy and mobilization in the country among women and women of color in particular that I am hopeful that we can translate this into legal change. And so I'm going to take the charge of the panel to focus seriously on the enforcement clause of the 19th Amendment as my focal point, and to start by saying that that's absolutely appropriate, especially as it relates to voting rights, because the legislatures in half the country and the courts currently are, by and large, hostile to voting rights and other political equality measures. As Kristen talked about, we've been in the midst of a more than decade-long battle of vote suppression, where now more than 25 states, voters are going to find it harder to vote than they did back in 2010, and this is continuing. So the states are not, solving this problem on their own. The courts have actually been, a lifeboat to some extent. We've been able to push back effectively and mitigate some of this in many courts, but that has only been a partial remedy, and we've been moving back. We've been stemming the flow of these vote suppression efforts, but we've been still steadily moving back. And most of the litigation has been largely under the 14th, 15th Amendments and the Voting Rights Act, and so not under, and we've even seen some under the 26th Amendment dealing with age, 18 to 21-year-olds, because a lot of these these bills have not only disproportionately targeted and impacted communities of color and some, in particular, young people and students, but because they've been intended to do so. And the courts are more and more finding that, and that's actually rather remarkable, the huge spate of judicial decisions that are actually finding that legislatures are intentionally trying to reduce the political power of communities of color or young voters at times. And so we haven't seen similar litigation on the 19th Amendment, even though, as Kristen points out, a lot of these kinds of laws do disproportionately burden women. And some of that might be because there's no real evidence that they are intentionally targeting women. This is just a byproduct of this broader effort. But, unlike this, not that courts should be interpreting these provisions so narrowly, but we have been in a situation where courts are only really willing to push back on these vote suppression and voting restrictions when there's a real reason to believe, whether they find it expressly or not, that this is that there are shenanigans and this is intentionally trying to roll back voting rights. And so courts have provided some check, but not really that much. And as Kristen also pointed out, they've actually affirmatively undermined voting rights. And we have there's a recent case out of Wisconsin that's a rather nutty case where a court has actually pushed and required an irresponsible voter purge that would have affected hundreds of thousands of voters in Wisconsin. That's been stayed on appeal. But really the biggest court rollback of voting rights was the Shelby County decision, which has dramatically rolled back voting rights protection across the country. But despite and what it did is it weakened Congress's power under the Enforcement Clause to pass laws to achieve political equality, and that is, of course, relevant to the section. To the 19th Amendment enforcement power, but even with that, given all of the limitations of the courts and in the state legislatures, the Congress really does remain a better long-term prospect for advancing political equality. And so we could use the 19th Amendment more narrowly to have Congress pass laws that, target those very specific kinds of restrictions that impact women, like voter ID laws, documentary proof of citizenship laws. We actually found that 34% of women who have documentary proof of citizenship don't have their current legal name on it, so that creates huge problems at the polls. But I think that the more impactful use of the 19th Amendment would go well beyond voting rights. And that's because right now, the most significant gender gap in political representation is not on voting. Even if these laws are disproportionately targeting women, women are still voting at higher rates than men. This is true across all racial groups, and in fact, African American women for the last 2 elections have been voting at higher rates than any other demographic groups. And so I wanted to flag 2 major areas where there's a gap. One is in office holding and in political candidates, and we can talk about all the details on that. But I also wanted to focus very specifically on who spends money in political campaigns. And unfortunately, in our current political system, perhaps even more than voting, our political voice and political power right now is defined by who spends money in political campaigns. That's an unfortunate byproduct of the Supreme Court's project of dismantling money in politics regulation, and we're now like a week out from the 10-year anniversary of the Citizens United decision. But spending money is political power. Studies do show that votes in legislatures and in Congress align much more closely with what major donors think than what ordinary voters think. And not surprisingly, women are not very well represented among major donors. It's only about 30%, and women of color are even a smaller portion of who gives to political campaigns. And we see this has huge implications for office holding and what happens. So one major reform that I can talk about precisely how that would actually address both of those problems is small donor public financing. And that's actually something that we have in place here in New York City, where you amplify where individuals can provide small contributions to candidates, and they get amplified at a ratio of 6-to-1 or 8-to-1, and it enables different people to run for political office. It enables different people to be significant as political contributors, and it actually changes who runs for office, what they run on, and what they do in office. And so there's a lot of data to back all that up, but I think the 19th Amendment can go even beyond the voting rights and frankly, all of the political conditions all of the other preconditions for political equality.
Great. All right, so we're going to do a couple back and forths up here, and then we'll open it out to the group. So I thought I would start, because we're in an election season, and I couldn't imagine having a conversation in the present, by just drawing out the group, likely Kristen and Wendy, but others, if so, they want to come in. Just a reflection on the present, we're 100 years out. Is there a positive story about women's empowerment here? I don't think I can take more bad news only. So we can hear plenty of bad news in the story today here, but I think maybe after the last night or two, I can't take only bad news. So maybe and I think in the panel this morning, we heard stories about the ways in which within communities of color and women of color coming together with some sense of political consciousness. It's certainly evident in terms of women who are acting inside of the Democratic Party today. There are stories it's in Julie's story about Virginia, but in any event, some positive trend lines as well as the stories about disenfranchisement, which are so dominant in this story as well. So just a few bright notes and then we'll keep moving.
Yeah, it's not all doom and gloom. I think that this election cycle is definitely historic, and one in which we're rewriting the books. I mean, the level of diversity that we've seen on this during this presidential season is unprecedented. But it has been disheartening to see that stage become increasingly more white and male over time, and it's in large part because of precisely what Wendy talked about, the outsized influence of money in politics. I do also think that we're still working to overcome a lot of racial bias as well. And that also informed kind of the difficulty that some of the candidates of color had getting traction and keeping pace with some of their peers. I do think that women are, we're hearing more stories about the first Latina, being elected to a leadership role in Virginia, the first, Black woman being elected as a state prosecutor in Florida. It's sad, though, in 2020 that we still have so many of those walls to knock down. But as Wendy observed, Black women definitely are turning out in high numbers and are participating at a very active level. We still have voter suppression, which works to counter some of the full impact that they might have. But there are definitely some positive trend lines that suggest that if we keep fighting and pushing, we are indeed moving in a healthier direction in our democracy today.
I'll just amplify that. In terms of office holding, there has been a steady but slow upward movement. We did hear about the historic 2018 involvement of women and women of color, but still, it was still only 36 of the 101 members of the freshman class, and only, I think, 13 of them were women of color, so it's still slow, but it has been definitely upward moving. It has not been even across the country or between the political parties. So in the Democratic Party, women and women of color in particular are advancing and into leadership positions at higher rates. Also in the Northeast and the West, that's happening more than in the South. So you see that there's like the lines of where voter suppression writ large and where we're seeing broad race discrimination are also aligning with where women aren't doing as well. But the other thing I just sort of wanted to add that's hopeful is the level of mobilization. And I think that does portend change. And there are two things I'll note about that. One is that women actually, mobilizing women and women voting has a multiplier effect, and there's actual research on that women are more likely than men to mobilize others, and that's even more so for women of color. And I think that, I think it was like much higher rates, like Black women mobilize friends, 84% as compared to 57% of white men. So I think that that mobilization could yield more mobilization. And also there's mobilization around reform. And a lot of these big changes that need to happen in order to level the political playing field, whether it's in gerrymandering or voting rights or money in politics, are all wrapped into two major pieces of legislation, HR 1 and HR 4, the Voting Rights Advancement Act and the Free People Act, that are actually getting a lot of mobilization, also largely led by women. So those are hopeful stories.
So I will just throw out there that the numbers that Kristen was sort of putting out to the surface about the disparate impact of the voter ID restrictions, the ways in which they're affecting women of color. I had grasped the race and the class impact, but I hadn't wholly focused in on the gendered element of them, or for example, the way that name change could factor into them. And it's interesting to start to pay attention to that. So I'm going to read you another Pew poll statistic that I just ran across recently that caught me off guard. This is a 2018 Pew Research Center survey. 51% of respondents reported it would be better for a woman seeking high political office to have children before entering politics, meaning, so half the people said that they should be done with this business before they enter politics. About a quarter said that a female candidate should wait until she's politically established before having children, meaning she shouldn't have children at all. That's a quarter of them. With an additional 19% reporting that it would be better for her just simply not to have children. So shouldn't have them at any point in her career. That's 20% of people answered that a woman in politics shouldn't have any children at all. And I thought that was actually, that people, it's one thing to have implicit bias, it's another thing to just answer the poll that way now and say 20% of people said just it was disqualifying to have kids. That, I didn't know that was how people answered the poll today. And so that's another way in which this is pieces of gender that enter into judgments just quite consciously about the way people are viewing candidates. But that is a piece of the story today. And so I was going to throw out a question. I told Sarah that I'd catch her maybe a little bit by surprise and just say, so this Pregnant Worker Fairness Act, we think of it as trying to leverage open women's economic opportunities. But in what ways does bending stereotypes about who belongs on the job or belongs at work ramify about who belongs as an actor in politics? Like, how often do we see pregnant women in politics?
Yeah, I mean, it's a really good question. Not that frequently, and that's why when Senator Tammy Duckworth was the first ever sitting senator to be pregnant and a senator at the same time, people's minds were blown that she could do both. And she did, and she succeeded, and here she is.
But it's interesting that there's like one or two or three, like,
oh yeah, I mean,
there's something there that we don't.
It's still a unicorn, right? And so I think but you can't be what you can't see, right? I wish I could attribute that to someone. I know someone brilliant said that. But you can't be what you can't see. And the problem are the structural issues that impact the ability to even run for office. So when we talked a little bit about the Pregnant Worker Fairness Act, but just taking still the kind of economic sphere and what women face when they're at work and having to juggle that. So let's paint a picture of a working woman's life. And I'm gonna paint, I apologize in advance, a slightly bleak picture. And this picture is even bleaker for low-wage women and predominantly women of color, right? So let's say a woman chooses to have a child, and I always have, Loretta Ross and the activists of the reproductive justice movement in mind of the vision of reproductive justice is the ability to choose to have a child, to not have a child, and to have a safe and supportive environment within which to raise children, right? And so let's say someone does choose to have a child. The first thing they might face, and they're working, the first thing they might face is pregnancy discrimination, right? And we spoke about that, the persistence of that. Then they don't have any paid family leave, right? Because we know most low-wage workers in this country do not have access to paid family and medical leave. So they have to go back to work, and we have clients who have to go back to work a week later after giving birth, right? Sometimes after having a C-section, which is a major surgery. I think we do a disservice to call it a C-section when it is actually a major surgery. And then they go back and they want to breastfeed, but they have no space or access to do that. So they, again, are forced to face that. Then they have this child, and the child gets sick. You know, you send them to daycare, it's a germ factory, and they have not a day of paid sick time to take, right? Because most low-wage workers in this country still don't have a day of paid sick time. Then they're in the sandwich generation, and so they have a parent that they need to care for as well, and they're a caregiver to that parent, but they're discriminated against and they can't change their schedule around because they're caregivers. So all along the way, you know, women are forced to choose between all of these things, right? At every juncture, a woman might be fired because she chooses to keep breastfeeding and she does it, and that's a source of food for her child. She takes the paid sick day because she has to pick her child up from daycare, right? So I think it's important when we talk about voting that, you know, all of these structures are in place and we, you know, talk about leaving work to vote or even run to vote, that's
So one of it
far
is
gone.
voting, but I think Julie was going to fill in with
Oh,
Virginia.
so I wanted to
Tell
say
Virginia
something a
story?
little bit, both local and global. So in
Oh.
Virginia, Jennifer McClellan, who introduced the ERA ratification bill, was actually the first pregnant delegate in the House of Delegates.
She was totally wild
And when
about
she was
this.
pregnant, she was asked by many people, are you going to seek re-election? Because how are you going to do that? And she said, why aren't you asking my male colleague, whose wife is also pregnant and who is about to become a father? And the other thing I want to say, since we were asked to say something positive, is that it doesn't have to be this way. I came into this work and this research by way of comparative constitutional law. So in other countries around the world, they have much higher levels of women in politics, including women who are pregnant and breastfeeding, holding office. And it's because of law. It's because over the past 20, 30 years, there have been movements to introduce gender quotas or gender balance rules in the context of electoral party lists for elections. And then there were constitutional conflicts about whether or not such gender quotas were compatible with constitutional guarantees of equality, to which an explicit amendment authorizing measures to promote equal access between women and men in politics, on corporate boards, in all aspects of life. You had those amendments in the late 1990s and the early 2000s that then made it possible for the numbers to increase rapidly in terms of women represented in politics. And I do think that if you come back to the United States, it's not totally foreign to us. Right after the 19th Amendment was ratified, a lot of states actually adopted what are known as 50-50 rules. And those are rules that are still on the books in many states. I think about 15 or 16 states have these rules that say that political party committees have to have one committee man and one committee woman. And those were actually challenged on 19th Amendment grounds. Men challenged that, claiming that was sex discrimination if you had to have at least one committee man and one committee woman. And those never made it to the Supreme Court. There were some lower court decisions about that. But it's also actually now come back, because in California a couple years ago, this isn't politics, but it's corporate boards, California adopted a law in 2018 saying that you had to have at least one woman on a corporate board for companies that are doing business in California, meaning you can't have an all-male board anymore. And that's now being challenged in litigation on 14th Amendment grounds, saying that this is an illegal gender quota, even though it's a measure to promote women's equal representation in positions of power. And I think these are some legal questions, whether we do it under the 14th Amendment, 19th Amendment, or the Equal Rights Amendment, if it can be legitimized. These are questions that I think need to be worked out in order for us to actually have real paths to a greater representation of women in politics.
This is where the kind of history that the first panel was talking about, the sense of the, profound and outrageous, persisting wrongs of the past could empower the idea of rectification. It's just that we're not in a country that wants to hear those words now, or there's not a nation that has a center that can, we can have the conversation. We'll be talking to a part of the country, which is not a reason not to have the conversation. It's just we're riven in some terrible place right now. I think, though, that there's reasons to keep the past in a conversation, to sort of start this conversation running, but with an idea that it can be built out in different ways. And there's, idea of both positive stories, like positive stories of leadership, as well as the idea of wrong. So this idea that law can do it is one pathway, but there's a zillion other pathways other than just imagining that you hold your breath for the state. That's the reason you have politics. Okay,
Can I
go,
make-
yeah.
Okay, just because I had so many reactions to that survey, first of all, why is it that all these people get to have opinions about whether women should have a child at all before, during, after her political career? And just even that question is asked is a legitimate question, and I'm interested if that survey was asked of men, probably not, or what they thought of men.
No, it was
but-
asked, that's a general population survey.
Yeah, no, I know, but the whole discussion
No, there's a
assumed-
huge breakdown. I mean,
Yeah.
I could give it to you. It
Yeah.
then goes
No,
to
if the question was
sub-demographic
asked, should
breakdown.
men have children before, during, or after, right? The same
No.
point. But, yeah, but point being, underlying all of this was the assumption that women are making a choice about whether to be pregnant before, during, or after, at any point in all these, right? That's, I just wouldn't be doing my job if I didn't say, right, the decision whether or not to have a pregnancy, to continue pregnancy, to end it needs to be part of this, because all of these steps along the way are based on the assumption that that choice was there, which it just is not right now.
Okay, great setup, because this is the last question before we go to the audience as a whole, which is, does anyone want to draw any connections between the whole RJ world and voting? And I guess you just drew one.
Oh, and voting.
Reproductive justice, I apologize. I apologize. Go, was that Julie, or should we just open to the audience?
Yeah, well, I think that, as Sarah was saying earlier, there's this broad understanding of reproductive justice that has to do with the choice to be a mother, the choice not to be a mother, and then the choice to have conditions where you can raise a child safely under, one would hope, egalitarian parenting. And this is something that I think has been central in other countries as they enshrined gender equality into their constitutions around the same time that women got the right to vote. So in Germany, when women got the right to vote, they did put in a clause about equality between men and women, and they put in a clause also that said that motherhood deserves the special protection of the state. And all of these things were taken to mean not only that women could vote, women were part of this constitution-making process, but also that there was a very important connection between equality and doing something about inequalities that stemmed from women's traditional role in childbearing and child rearing. And so what that meant was that the accommodation of pregnancy and paid maternity leave were part of what it meant to have sex equality from the beginning of constitutional sex equality. And I think we've taken a different path in the United States from that, and I think it's a path that I'm not necessarily saying is the wrong path, because certainly when you entrench motherhood into the Constitution, that also leads to expectations that fix gender roles rather than change them. And so I think that these are important questions that we need to continue to work out through the law of constitutional equality.
Well, I will just add to the fact that everything that we have about the world of reproductive justice and how we reason about the world of reproductive justice under the Constitution assumes that it's a new set of claims on the Constitution, and all of that is an artifact of the persons who are most concerned to assert claims about reproductive justice having been lately enfranchised. And had their voting power been originary, then our understanding of reproductive justice would itself be originary. And we can never forget that. The way that it gets made peripheral to our constitutional order is an artifact of this very conversation that we're having. If women don't get the vote till 1965, if that's when we want to date it, that has everything to do with the way that these claims get pushed to the side constitutionally. That's at least one connection to make. I want to make sure that we get the audience in here. And so with that, I'm going to say that the mic is available to, and here we go.
So thank you for this panel. I was wondering how queer women and trans folks and gender non-binary folks fit into this, especially given, say, how the ERA is drafted or things like gender quotas, are they going to not be protected?
So, I think one of the best moments as I watched the Virginia ratification debates in the middle of January was Danica Roem, who's the first transgender woman elected to the Virginia legislature, give a speech about how she and her very conservative mother didn't agree on a lot of things, but the ERA was one of the things they did agree on and support wholeheartedly. And so I do think that the Equal Rights Amendment, as the 19th Amendment, is broadly worded on account of sex. And I think that now in the 21st century, regardless of what they might have been thinking when the 19th Amendment was ratified, I think now in the 21st century, the word sex has evolved in our law to include gender stereotyping, gender identity, and sexual orientation, although there is contestation about that. But I think that the folks who are ratifying the ERA today, including Pat Spearman, who's an openly gay ordained minister who served in the military in Nevada, right? I think there is a very inclusive understanding of how sex is to be understood because of the moment that we're in.
One of the things that's fascinating, wherever people are with respect to the ERA, meaning whether they're engaged with it or not, one of the things that's fascinating is how the understanding of what it's about it's a half century, well, it's now 100 years old, right? And whatever it's about today is different than what it was about a half century ago, appropriately so. So the ways in which it's imagined now and the carriers of it are different. So that's at least something that Julie's been following. Others?
Thank you for this terrific panel. My question is how we can retell the story of voter suppression and restrictions as being not just about race but gendered. So the examples that Kristen and Wendy gave about voter ID laws, name correlation, how that impacts women with hyphenated names, also restrictions on bringing a certain number of children into the polls, and then historically, the poll tax and literacy tests as impacting, especially poor women, women of color. And the importance of retelling that as a story of not only about race, but about gender, so that we can develop a broader coalition, right? Because, race is being used to fracture our collective interests as women, and so oftentimes women vote against our interests. Whether it's voting for Trump only a couple days after the Access Hollywood tape, and then he goes on to set up the Electoral Integrity Commission that Kristen talked about, or other ways in which women vote against our collective interest as women. I love the example that Wendy gave about the 19th Amendment litigation under the Enforcement Clause to address voter ID laws, and I wonder how we can broaden that in terms of public education to retell the story so that women can embrace this story around voter suppression as well.
I think it's a great idea to tell a public story this year about the 19th Amendment and voting and link it to the struggles we're facing across the country. It's also the 150th anniversary of the 15th Amendment, and I think both those stories and telling those stories together would be a great idea at a time when really there is a growing movement and mobilization. I also wanted to link that back to the sort of reproductive rights with sort of one small other factoid, which is it was only in 2018 that the Federal Election Commission finally said that women candidates can use campaign funds, actually all candidates can use campaign funds for child care expenses. Beforehand, they had to find the money elsewhere and not use any campaign contributions, and actually only 14 states currently allow that. So just to sort of think about the other ways in which the way we structure our political life and access for candidates, I think is another piece of that story.
Mm-hmm. I think I would just say that I think it's important, though, for us to still remind ourselves that race is different, and efforts that have been made in the country to lock out African Americans from the ballot box are particularly odious. Violence, lynchings, Jim Crow, are all part of the story that surrounds kind of efforts to lock Black people out of the ballot box. But that said, I do think that there is healthy work that we can do to lift up the ways in which officials today have put a target on voters in ways that not only impact people of color, African Americans and Latinos, but women and students and the elderly and low-income people. So I've just kind of made it an important part of the work I do to make sure to kind of lift those narratives up and appreciate this space to kind of talk about some of these battles that we wage as voting rights lawyers in a lens that kind of makes clear that the intersectionalities, the ways in which, you know, race and gender can kind of compound the effect at the end of the day that these restrictions have on the electorate. But I think there is work that we need to do to lift up these narratives. The Voting Rights Act is, you know, the central tool that we use as lawyers to fight back against a lot of voter suppression, and the basis there is race. And so I think, you know, because of that, you know, in Texas, we litigated against the state for 5-6 years without really talking about this kind of gender impact surrounding the conceal and carry permit. But it's gross that, you know, you have an ID law that 75% of men who, you know, people who have it are men. That probably is a basis for that conceal and carry permit to not have been a permissible form of ID. So it is a moment that we should all kind of embrace to kind of lift up these stories and to tell the narrative in a different way than we ordinarily do.
We have one question in the back.
I was actually going to share an experience more than a question. I ran for a state committee under the as a woman, where you had to have one of each, and I ended up getting thrown off the ballot for technical reasons, which I will not, and I challenged it all the way up to the Court of Appeals. But and one of the things they were talking about in the Court of Appeals was this issue of transgender. Now, in my political group, there's a transgender person who's challenging a woman for district leader. I think it's district leader. It could be state committee. So, you know, this is kind of a touchy problem right now. That there's a conflict between trans and the protection of women for these beginning political positions.
I just asked what was the problem that she was identifying with having a trans person wanting to obtain office.
It's just that these positions were put into place in order to have more women in in political positions. These are entry positions, and the women who are they're not, they were men and now they're women, and so that it's just this, I don't know, it seems like there's fewer positions for women. It's declining. Well,
so it's not my panel, so.
I guess so.
Well, all right, we have now 2 minutes. Rabia, did you want? It's okay. All right. You don't have to, no, you don't. Wow. Okay, we have 2 minutes to discuss this question. Or?
Who wants to I can jump in and just say.
All right, this is like, it's a fabulous and a huge and intense conversation, and I could imagine if you only have 2 positions, it's going to make for an enormous conflict. And I could imagine also restructuring the opportunity so as to make it more inclusive. So we could have this incredibly intense debate about who counts and who gets included, or we could also talk about restructuring the framework so as to have more people in. What?
It wasn't that I was saying these women shouldn't be considered women. It's just that the judges were really struggling with this as an issue, that we're dealing with my.
Well, of course we want, all right, then, all right. Do we want to have a conversation? Is that where we're going to go? No, it's your choice. With 1 minute? That is not a minute.
Okay, so say no, so say no.
Can I just jump in and say no?
Yes.
So just to address, I think Riva's point is well taken. There is so much, and I think this is where you get also at the need for intersectionality in the work that we do, right? So take pregnant worker fairness, for example. All of the laws are gender neutral, right? We need to ensure that anyone who is a pregnant person can have the protections of the law. And I think what happens is, and the oppression that comes with being historically discriminated against is that, and two groups being historically discriminated against, is that the patriarchy forces and pits us against each other. I think we see that with race and gender. I think we see that with LGBTQ rights and women's rights. And I think that is where the difficult work comes in, is to say there is space for everyone, that we have to work for everyone, that our oppression is your oppression, and that's how we move forward in the work that we do and how we reach equality and the fundamental purpose of the 19th Amendment, I think.
Well, I do want to say this. I have no idea of the background facts of this scenario, and I would never want to end this panel by not saying the following. The whole point of the amendment was to open up opportunities for excluded groups. We've heard everything today about ways in which the amendment failed of that purpose as well as succeeded. So in the moment that you just put on this table, there's an insurgent group looking to have opportunities open for it. So we wouldn't want to close this panel by saying, no, go away. So it's really important that the trans people who are trying to make their voices heard in politics find that opening. Whether it's best accomplished by taking opportunities for inclusion and shutting other groups out, not so clear to me that that's the only way to accomplish that. I don't know at all enough about the facts there. All I want to say is the situation needs more investigation. We need lunch. And it's been a great conversation. I'm sorry, Deborah, that you didn't get in there because I was looking forward to hearing from you. But in any event, I want to thank our panelists and look forward to continuing further, okay?